The Hearing, a legal podcast from Thomson Reuters.
The judge called Letby's actions a cruel, calculated and cynical campaign of child murder. And since this case, what do we have? Well, we've had a number of publications, TV documentaries and public speculation. Why is this case so striking? And what's made this case infamous and controversial?
Hello and welcome to this episode of The Hearing. We're going to be looking at quite an infamous case in the UK today, the case of Lucy Letby, but we're really going to be looking at this case as a way of discussing expert evidence in trials, in particular criminal trials, and what that means for us as lawyers and what that means in the justice system.
The Hearing.
Hi, my name is Dr Sarah Bennett. I'm a lecturer within the School of Law and Justice Studies at Liverpool John Moores University.
Thank you very much, Sarah. I'm really looking forward to our conversation today. And we're going to be talking about the Lucy Letby case, which is obviously quite a famous case in the UK, dealing with incredibly difficult, a really heartbreaking subject. Would you mind just summarising the facts of the case before we start to give our listeners some context for the discussion that we're going to be having?
Yeah, of course. So just by way of a very brief overview as to the case, Lucy Letby was a neonatal nurse at the Countess of Chester Hospital, which is situated in the north of England. Between June 2015 and June 2016, a cluster of babies under Letby's care suffered sudden, catastrophic collapses. Now, in Letby's trial, the Crown alleged that Letby had deliberately harmed them using methods such as injecting air into bloodstreams, overfeeding with milk, and interfering with breathing tubes. It was after a lengthy 10-month trial in August 2023, Letby was convicted of 7 murders and 7 attempted murders. It was then in June 2024, she was convicted of an 8th attempted murder at retrial. In the case, the judge imposed whole life orders for every single count, and that is 15 separate life without parole sentences. This was symbolic and significant. It marked the death of each baby and each baby's life. When sentencing Letby, the judge stated, Letby had acted in a way that was completely contrary to normal human instincts of nurturing and caring for babies. He went on to state that Letby had acted in gross breach of the trust that all citizens place in those who work in the medical and the caring profession. The judge called Letby's actions a cruel, calculated and cynical campaign of child murder. And since this case, what do we have? Well, we've had a number of publications, TV documentaries and public speculation. And I think you touched upon this. Why is this case so striking? And what's made this case infamous and controversial? Well, to briefly outline, it's the fact that we have no direct eyewitnesses. We've got no direct confession, no CCTV evidence. What the prosecution in the case had was circumstantial evidence, medical opinion, which has since faced intense scrutiny, circumstantial patterning, and some deeply troubling handwritten notes.
Thank you very much for that summary. That's really helpful, actually, because I'm going to confess something now. I've only recently read about the case and I haven't read it in a great deal of detail. And I'm going to be really honest and say that as a mother of 2 children, I felt like it wasn't something that I wanted to spend a lot of my time reading about and reading into, and the speculation, because I probably find it a bit upsetting. So I was aware of it, but I didn't really look into it deeply at all until the expert panel led by MP David Davis released their results. And then, of course, the lawyer in me, which I just can't I can't make them be quiet, even if I might want them to. The lawyer in me kind of started to say, hang on, this looks quite interesting as a lawyer. And so how do we end up with the case where we have a situation now where the case has been tried, multiple convictions have been obtained, we have an appeals process that is exhausted, but so late in the day, we have an independent panel of 14 experts who come together to challenge that evidence. And that was what really piqued my interest. How does a panel like that get convened when you have a case which has been tried, convicted, appeals exhausted? How does that happen, and why?
Well, I think we have to go back to the trial in this case, because the reason as to why the panel was convened is linked to the actual trial which took place at the outset. So at trial, it was the paper of Dr. Shuley which was used by the prosecution. After that paper was used at the trial, Dr. Shuley asserted that this paper was misused. He was never called to give evidence during those proceedings. And then it was subsequently in April 2024 when Letby appealed the conviction, and this appeal was rejected. Dr. Shuley had testified at that appeal, expressing concern surrounding the medical evidence which was used during Letby's trial. So it was following this rejection of the appeal that it was the expert, Dr. Shuley, whose paper was originally used by the prosecution. He went to Letby's legal team and he proposed he would convene this international expert panel to examine all of the medical evidence in detail. And Dr. Shuley asserts, and he's asserted during press conferences and with the subsequent publication which was produced, that the objective with the panel was to provide an impartial, evidence-based report about the causes of death and injury in all of the cases involved in the trial. And then that's how we comprise of the 14 experts. We've got 10 neonatologists, 1 paediatric surgeon, 1 paediatric infectious disease specialist, 1 senior neonatal intensive care nurse, and another paediatric specialist. Now, what's stark in relation to those expert panel findings is the conclusion in which they've really reached. And the conclusion that was reached by the panel is that there was no medical evidence to support malfeasance causing death or injury. The panel also went on to assert in their findings that death or injury of affected infants was due to natural causes or errors in medical care. They also stated that there were problems relating to the medical care of patients at the hospital within the neonatal unit, and that there were problems in relation to teamwork and interdisciplinary collaboration at the neonatal unit. And if we just pause there, that these are extraordinary statements. You know, when we consider that Lucy Letby is considering 15 whole life orders. So to come back to that question, why so late on in the day? This is because of our adversarial system. Our adversarial system will only bring forward the experts each side chooses. So at trial, the Crown called paediatricians and pathologists. The defence called no neonatologists. The only individuals who were called by the defence was Letby and an estate plumber who'd worked at the hospital since 1986 and who subsequently gave evidence regarding plumbing problems that occurred at various points in the unit.
So no experts, medical experts, other than Lucy Letby herself being a neonatal nurse, spoke, given that seems incredible, given the weight of medical evidence that must have been required in this case, given, as you say, there's no witness evidence, everything is circumstantial. That's quite remarkable.
But if we look at the provisions and what English law requires, there is no need. The burden is upon the prosecution to prove. There is no requirement on behalf of the defence to bring forth experts, and it's something in which the Court of Appeal even noted upon appeal that experts were instructed by Letby's team. However, the decision was made not to put forward those experts at trial.
That's interesting in and of itself. But I'm going to move on to my next question now and leave that composting in my brain for later. We've talked about the trouble with expert evidence on the hearing before, and I certainly remember from my days when I was a trainee lawyer liaising with experts whose testimony was going to be so technical that the judge was going to struggle to understand it, but let alone an entire jury. So what are the implications for this case in particular? We've already touched on it a little bit, but what are the implications for this case and the overall problems that we see with the use of experts in our system?
So we look at it broader firstly. In many cases, experts play a key role. Expert opinion, you and I will know, is a crucial yardstick for a conduct to be really judged against when we get to the courtroom. It's used to furnish the court with information which is outside the knowledge, the skills, the expertise of the judge and also the jury. But what we must emphasise and what is key is that when we're dealing with expert witnesses, their duty is to the court. The duty of the expert witness is to help the court achieve the overriding objective, to give this objective and unbiased opinion in relation to matters which are within their expertise. And in adversarial trials, like we have in Letby's case, it's for the jurors to hear potentially competing expert evidence. The jurors hear experts dueling with no easy way of knowing whose science is stronger. And despite experts overriding duty to the courts, you'll know that there's still this concern that we have something which lawyers refer to as hired guns within the courtroom and whether or not they remain. You know, you've got the statements which were made by Lord Wilberforce in the case of Whitehouse and Jordan, talking about the need for experts to be independent, uninfluenced by the exigencies of litigation or the party who's instructing them. Yeah, I think within my own research, what I've found is in a recent survey of expert medical witnesses in 2024, when they were asked, have you experienced hired guns in your field? 1/3 of experts responded that they had. And this is concerning across the legal sector as a whole. This is what experts are reporting. And in Letby's case, we have the lead prosecution expert, Dr. Dowie Evans. His testimony was pivotal. But since the case, what we've had is this speculation and concerns which have been raised by the defence regarding his impartiality. Letby's defence team themselves have accused him of shifting his views, something which Dr. Evans has denied. And as I touched upon before, this is where it's key in Letby's case. What we've had, I talked about this idea of dueling experts. In Letby's case, we didn't have these experts, we didn't have these defence experts. And the question which was on your lips and which will probably be on the lips of many other listeners in this podcast is, why was there an absence of defence experts? And the answer is, we don't know. And this is where legal privilege comes into play. Privilege protects those communications between a lawyer and a client. And unless Letby waives it, her legal team can't explain to us, the public, what advice was given or why no experts were called during the trial. And of course, you'll agree that this is a vital safeguard of our justice system. But it means that the public may never know why her defence looks so sparse on the expert front at trial.
And of course, the public at least, I mean, the court won't be allowed to draw inferences from that, but the public might well start drawing influences of no doctor, no medical expert wanted to stand up and defend you. And there's, you will draw a conclusion from that, and not a good one, not a healthy one, which is, I think, partly why for me coming to look at this case, it was so shocking that almost from out of nowhere, because I hadn't really been following it, but almost from out of nowhere, this panel of incredible world-renowned experts who weren't involved in the trial at all suddenly just stepped in and said, as you said earlier on, the most... they weren't hedging their bets in the statements they made about the care of the babies. They weren't being equivocal in the way they were describing the operation of the hospital in relation to that care. They were incredibly stark in the pronouncements that they made. They were incredibly clear in the pronouncements that they made. And they did it outside of a court setting because they weren't really invited into the process until, I suppose, it was too late. But I think for me, it also throws up other questions. Like, in a case like this, even when you do have the dueling of the experts, for the main expert on the side of the prosecution to so grossly misunderstand or misrepresent Dr. Shuli's paper and the conclusions of Dr. Shuli's paper in relation to the evidence at this trial. My understanding is that Dr. Shuli was saying that that's not what my paper says, that my paper does not support the conclusions you've just taken in relation to this case, and I'm going to explain in great detail why. It seems kind of shocking to me that somebody would be forced into that situation, that Dr. Shuli would be forced into that situation, almost having to get up and defend his paper in front of the court because somebody has misrepresented it so badly.
And I think that's something in which the court system, and that's something in which, the case now appearing and going to the criminal case review, which we'll discuss, obviously, which needs to be discussed. But I think that's something for which the legal process to look at in greater detail. The concept as to why no experts were called on behalf of the defence is obviously an answer which we don't know. We simply don't know the answer to that question, and it would be pure speculation on my front as a lawyer to be able to put forward that response. I think just working with the information that we have, it's a question in which we all want to know the answer to.
The hearing.
On the outside, you're a lawyer, calm and cool, but inside there's a passion to perform, a drive to be absolutely on your game. You prepare hour after hour, day after day in the pursuit of excellence, relying on superior resources, serious preparation, and total confidence. That's the advantage we give you. Be your best with Thomson Reuters Practical Law.
As allegiances are tested.
You're gambling with World War III.
And regimes fall.
Fighters and civilians continue to stream in from other parts of Syria.
No matter where the story is, Reuters World News podcast is there. We make sense of the news shaping our world and give you everything you need to know in a 10-minute podcast every weekday. I'm your host, Kim Vanell. Listen and follow wherever you get your podcasts.
I'm not a criminal lawyer, but I have done one module of it as a trainee, and obviously I'll be basing everything off that in my next question. But the thing that gets drummed into you as a criminal lawyer versus being a civil lawyer is the two different standards. Obviously, there's the beyond all reasonable doubt and the balance of probabilities standards. Now, and what shocked me, I think, as well, and I know I keep using that word a lot, but I really was stunned when the panel came out with their conclusions. One of the things that further stunned me was how on earth can we get to a standard of beyond all reasonable doubt, and yet a panel of 14 people can immediately step in and say, not only is there reasonable doubt, but we think that the evidence actually flows the other way. It flows well away from guilt. It isn't even a question of beyond all reasonable doubt, especially when there was no direct witness evidence. It was all built on expert testimony, My understanding, it wasn't just built on expert testimony, but it was built on presentations of certain statistics and probabilities, using evidence which had been, presented in particular ways that didn't perhaps necessarily give all of the statistics and allow people to look at all of the statistics around infant incidents in that unit. So how much of an understanding of probability is it reasonable for jurors to have, and how do we get to from the original case? How on earth do we get to beyond all reasonable doubt, even on the evidence that was presented? Because the first thing you said when you described the case, which is the thing that I noted when I started reading into it more, was so much of this was circumstantial. How does that get to be enough?
I think from the outset, we need to note that for laypersons, that the criminal law, it's a time-honoured standard that the jury must be satisfied beyond reasonable doubt. And we can see that from 1969, looking at the case of Walters and the Crown. But looking at the formulation of it and how do we actually establish, first of all, what is beyond reasonable doubt? There's been some type of direction which has been given by the court. So, for instance, if you take the case of Walters, the Privy Council there said, well, it's an opinion that it's a matter for discretion for the judge to choose the most appropriate set of words in a given case to enable a particular jury in question to understand the standard of proof. They said in that case, reasonable doubt is that quality and that kind of doubt which, when you're dealing with matters of importance in your own affairs, you allow to influence you one way or another. And then if we skip forward to 2022 and you've got the case of Mohammed, the jury in that case actually sent a note to the judge and they said, we're told that we must be sure, but how sure must we be? Is 99% enough? Do we need to be 100% sure? And it was in that case that the judge actually said, you don't need to be 100% sure. The courts don't use percentages. And they said, just think about how you use the word sure in your everyday life when you're making important decisions for yourself or your loved ones. So with that in mind, talking about the Letby case, as you said, there was no direct evidence. No one saw Letby specifically do something. But that's not unusual in criminal cases. Many cases rely upon circumstantial evidence. And what it's really about is using this evidence to build a picture, piece by piece, until that conclusion becomes clear. So the prosecution in Letby's case rested on several key pillars. They used information such as a shift chart showing that Letby was present during these multiple patient safety incidents. There was handwritten notes that were interpreted as confessions, blood tests suggesting babies may have been poisoned, and medical records used to support theories on how attacks were carried out. And really leading the charge was Dr. Dowie Evans, the expert who developed many of these theories. So yes, expert testimony played a huge role in the case, but that's by no means unusual. And when we come back to this question of beyond reasonable doubt, I think what the legal system does is it acknowledges that jurors are laypersons. They're not experts in mathematics or statistics. And so therefore, the courts don't generally expect jurors to say or have formal training in probability. But what they have been told and directed to do and are expected to do is use their common sense and everyday reasoning to weigh the evidence. And that's what juries do in many criminal trials on a daily basis.
So then, what do you think this means for the lawyers? One thing that you just said, which I'd like to pick up on, which was that some of these theories being presented as the key points for the prosecution were developed by the expert understandably so, because the area is so technical. But as lawyers, how do we build a case or defend a case when we have technical knowledge which is so specialised? As lawyers, we don't necessarily even fully actually understand the arguments that perhaps we're even presenting in court. You know, do you think that lawyers must start to have some expertise themselves in order to advise in these situations? Otherwise, are the lawyers not taking on and not interrogating ideas, lines of arguments which are incorrect and they can't recognise them themselves?
I think what we've got to reflect upon is that in many cases, especially those cases which involve complex medical or forensic issues, experts are pivotal. But here's the thing, as lawyers, they can't just let them jump straight to the conclusion. Lawyers have to build this journey for the jury, step by step. So starting with the physiology, then moving to the clinical signs, looking at the blood gases, the imaging, the post-mortem findings. And after that, also presenting alternative explanations. Was the sepsis, ventilation failures, clotting disorders, and air embolism? Was it even just simply a coincidence? And what's key here is, if the jury can't see the forks in the diagnostic road, you're asking them to choose a destination without ever truly showing them the map.
Mm-hmm.
Now, think about also who is speaking in the case. In this case, we had the Crown. The Crown in this case relied upon a paediatrician, Dr Dowie Evans, and he remained the lead expert throughout the investigation and the trial. His conclusions, as the Court of Appeal have acknowledged, were reviewed by Dr Bowen, a practicing consultant neonatologist at that time. And as we've touched upon throughout, the defence, yes, they had experts. They'd instructed a number of expert witnesses of their own, and many reports were served for them before and during the trial. But pressing back on that point, there was no expert evidence called by the defence. The defendant only presented their own testimony and that of an estate plumber. Now, legally, I've emphasised that the defence doesn't have to call an expert. The burden's on the prosecution. But in practice, what did that mean in this case? Well, it meant that the jury only heard one medical opinion. They only heard one version of events. And I think from a legal perspective, what's key for lawyers in these cases then when we're dealing with these experts? Well, it's for a lawyer to pre-mortem their own case. Before a lawyer walks into court, they must break down their own theories, dissect them, in essence. Find the weak spots before the other side does. And that way, it's crucially, you can reinforce those areas or prepare your counter-argument. I always like to say it's akin to a game of chess in a courtroom. The best players don't just plan their moves, they anticipate their opponent's response. And you come back to this idea of, are lawyers equipped with the skills? Well, lawyers operating in this domain in clinical negligence cases, in these types of cases, whereby you have some type of medical medicine as being brought to the forefront of the claim, they are specialists in that sense. They have the tools and they have the training. And in cases like this, though, what's key is that these lawyers guide the court, not just through the law, but through the science, the strategy, and the story which is being told. And I think that's key.
Interesting. So then what's next for Lucy Letby's defence team? I know now that she has exhausted the appeals process, but having a panel of international panel of independent expert witnesses making such incredible statements publicly, does that create the ability to reopen the case?
Well, as you said, yeah, Lucy Letby's legal team has exhausted the standard appeals process. In July 2024, the Court of Appeal rejected her bid to overturn the convictions. But that doesn't necessarily mean that the case is closed forever. We know that there's been an application submitted to the Criminal Case Review Commission, or the CCRC, on Letby's behalf. And just by way of a brief background, the CCRC is this independent body that can investigate possible miscarriages of justice, and it has the power to send cases back to court. And in this regard, it's responsible for independently reviewing suspected and alleged miscarriages of justice in England, Wales, and in Northern Ireland. In relation to whether or not that will be successful and how long that investigation will take, we don't know. We do know that the case involved a vast and complex body of evidence presented during Letby's trial. But if we look beyond Letby's individual responsibility, I think this is where my kind of research and my interest sparks here. It's looking at the deeper questions which have been exposed in the aftermath of this case regarding patient safety, whistleblowing, and potential systemic failings within the healthcare system itself. In this case, we have Lucy Letby. She was given a whole life order, and that sentence addresses her personal culpability. But I think the question to be asked is, what about the hospital that employed her, the Countess of Chester? The questions which are asked are, were early concerns properly escalated? Were there failures in governance at the hospital? And did senior managers allow these risks to continue unchecked? And for those who are aware, in response to these questions, the government has launched the Thirlwell inquiry chaired by Lady Justice Thirlwell. And that inquiry was tasked with examining those questions. And I truly believe that those findings will be critical in determining whether systemic and managerial failings within the NHS Trust contributed to the conditions which allowed Letby to offend. And they may also influence whether or not further action is taken, potentially including corporate manslaughter charges against the NHS Trust. And I think if you look at that possibility, in October 2023, Cheshire Police actually confirmed that they'd launched corporate manslaughter investigations into events at the Countess of Chester during 2015 and 2016, the period when Letby's crimes occurred. And more recently, we have 3 senior hospital managers being arrested on suspicion of gross negligence manslaughter. And truly what the Thirlwell inquiry's recommendations are expected to do is shape these wider regulatory reforms, particularly around how hospitals handle internal warnings and the role of leadership and safeguarding patients. Because at the end of the day, whilst one individual has been convicted and we await the outcome of the CCRC, I think what's key is that the broader story is far from over in this case.
Yes, I suppose you're right in that what my lawyer's brain automatically leaps to next is either the conviction is completely sound, all of the convictions are completely sound, and the prosecution team were completely correct, in which case there's a safeguarding issue. How was that situation allowed to go on for so long before somebody stepped in and stopped it and prevented any more deaths? Or we have a situation where those convictions are not sound, the independent panel's findings are closer to the truth, if not the truth, in which case, how are we going to prevent more of that situation happening in the future and prevent more of those tragedies. But I think you're right in that sort of taking a step back from, is the conviction sound? Is the conviction not sound? It doesn't matter which way you look at it. There is a piece of future work of prevention, and all the soundness or not of the conviction does in relation to that is tell us where best to look next to prevent it happening again. Would you say that's fair?
Yeah, I would say it's fair. I think we can't enter into the realm of speculation, what's going to happen in the future. It's in the hands of the CCRC as to whether or not there has been a miscarriage of justice, and it isn't my place specifically to speak upon the innocence or the guilt of Lucy Letby. But I think it is key that going forward, that there is this idea that patient safety was compromised at specific levels, and it's about learning and reflecting, and that's specifically what the Thirlwell inquiry is directed to do, to ensure that lessons are learned, to ensure that patient safety is optimised in this, following the tragedy of what's happened. And what mustn't be disregarded or forgotten about is that children have died at the end of all of this, and it's ensuring that safeguards are implemented to prevent any such fatalities ever occurring again.
The hearing.
When faced with a case like this, a case of extreme tragedy, of horrific circumstances, I think it's important on all of us to look very carefully at the circumstances surrounding that case. All of the circumstances, the conviction process, how we got to that point, to see, as we discussed with Sarah, where there are opportunities to make sure that we can prevent future crises. And that is a critical part of this journey. And it's a critical part of any journey with a case like this, and one that lawyers often don't get involved with. Once our cases are done, if we're not intimately involved in an appeals process, or if an appeals process has been exhausted, then our involvement sometimes stops. And I think what's so interesting here is saying that there are systemic issues that we can be looking at, either as a profession or as individuals, to make sure that these incidents, however they happened, don't happen again. If you're interested in this content, then please do like and subscribe. And if you've got a question or a thought about something we talked about today, then email us on thehearing@thomsonreuters.com. I've been Becky Annison. Thank you for listening.
The Hearing, a legal podcast from Thomson Reuters. To find out more, go to tr.com/The Hearing or subscribe via iTunes, Spotify, or wherever you get your podcasts.